Hello and welcome to See You in Court, the podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. This podcast is a collaboration between the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Your hosts are Robin Fraser Clark and lestertate, who are both past presidents of the State Bar of Georgia and currently serve on the board of directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good afternoon, friends and lovers of the law, and welcome to See You in Court. I am Robin Fraser Clark, and with us here today is our fabulous co-host, Lester Tate. Lester, how are you doing today?
I'm doing fabulous. And that's the nice thing about not doing the intro. I get called fabulous every week when really that should be your credit, I think. But
no, you are fabulous. That was the only word I could just popped in my mind to describe you. So we had a big football weekend, big Georgia win, but unfortunately they beat your Gamecocks.
They beat South Carolina. I think we did really well in the first half.
You sure did.
And then my Georgia Tech team got beat by Ole Miss. So I didn't have any winners except the Falcons. But I think we hadn't introduced our guest yet today, but I saw he's a Texas Longhorn here. So he's got to be having a happy football season there, I'm sure.
We're having it's a rare period of winning for us that I'm sure soon to come to an end.
Very, very exciting. And Lester, I got to see our good friend and colleague Jay Cook, a former president of the State Bar and former guest on one of our first guests on the podcast. I had dinner with him Friday night in Athens, so it was great to see him. Jay is
a titan of the Georgia Bar, and it's always good to see him. And I'm friends with him even when he's rooting for the Dogs against the Yellow Jackets or the Gamecocks.
Yeah, for sure. Well, today, and I don't know if you noticed, Lester, but I said good afternoon. You did. For a change, because we are taping this late in the afternoon on Monday, September 18. Usually I say good morning. And I guess with your kind of football weekend, that meant a lot of bourbon for you.
Well, there was a lot of bourbon. There was also this little matter of me having a birthday last week. On the day before, I had to go do 2 days of trial. Yeah. So I really couldn't celebrate, so I postponed it to the weekend. So we had barbecue chicken wings, bourbon, and football from starting with game day and going till the last horn. They don't shoot guns off anymore, So it was a good fun day. I enjoyed it.
Yeah, it sounds like a great way to celebrate your birthday. So happy birthday. My fellow Libra.
Yes. Yeah. No, I'm a Virgo. I'm the Virgo.
Oh, you're a Virgo. I'm sorry.
That's right.
Okay.
That's right.
Well, today we are excited to be talking with Texas lawyer Martin J. Siegel, who is also a newly published author, and we'll be exploring his new book, Judgment and Mercy, The Turbulent Life and Times of the Judge Who Condemned the Rosenbergs, published earlier this year by Cornell University Press. Let me introduce our guest, Martin Siegel, to our listeners. Martin Siegel's law practice focuses on briefing and arguing complex appeals in federal and state courts. He also handles key motions in trial courts and consults on legal analysis and strategy. Siegel has won appeals in the U.S. Supreme Court, federal appellate courts around the country, and the Texas Supreme Court, and has repeatedly earned recognition from peers. In 2012, he was elected to the Texas Bar Foundation, a fellowship limited to 0.3% of licensed Texas attorneys each year based on regional peer nomination. The Texas Bar Foundation supports projects providing affordable legal services for underserved communities, promotes professionalism, and educates the public about the justice system. Martin graduated from the University of Texas undergrad and then Harvard Law School. After graduating from Harvard Law School, Martin was the last law clerk for Judge Irving R. Kaufman, the subject of Martin's new book, who served on the Second Circuit. Martin then served as an assistant U.S. attorney in the Southern District of New York and as special counsel on the staff of the U.S. Senate Judiciary Committee from 2000 to 2001. He now practices law in Houston, Texas, and teaches American legal history at the University of Houston Law Center, where he also directs the Appellate Civil Rights Clinic. He also serves on the board of the Anti-Defamation League, Southwest Region, and has drafted state legislative testimony and amicus briefing for the ADL. Martin is also a senior editor of litigation, a quarterly publication of the American Bar Association's section on litigation. Wow. Martin, welcome to the show.
Thank you. Thanks so much for having me. Really appreciate it.
Yeah, that's great.
Yeah.
I love the litigation magazine that the section puts out. It's one of the best legal publications around.
We're really glad to hear that. I've been on that for a number of years, and I need to tape that and play it at our next meeting, because often we're not sure how widely it gets out there, who reads it. But that's great to hear.
Martin, I love it too.
Thank you.
I was going to say I love it too, and that's how I've even found out about you, Martin, and the book that you've written.
Yeah, that's right. I had a short piece about the book.
So I watched the Paxton impeachment, and I didn't see you on there. I thought every lawyer in Texas was involved in that case at some level or whatever.
Yeah, it's a poor commentary on my practice and my status here. That I was one of the few not involved, but in the end, I'm not so sure that's bad.
Well, let's talk a little bit first before we get into your book, and I'm very interested in that. It sounds wonderful, but I wanted to share with our listeners just a little bit about your law practice. Can you tell us? You worked in the United States Senate as a staffer, which Lester also worked in Washington. For a period of time before he started practicing law. But then you came back to Texas. I guess you're from Texas originally and came
that's
back
right.
to
I'm
Texas.
from Houston, and I grew up in Houston, so I moved home at the end of 2001. That's right.
Martin, in looking at the TV coverage of the Trump indictment and everything, everybody that they have on as a legal analyst has been an assistant U.S. attorney from the Southern District of New York. And so I saw you were doing that, and I was like, going to have to ask him, what is it about the Southern District that makes you an expert in everything that comes after that?
Right. Well, the best expression about the Southern District, which you might have heard at some point, is they have been around so long. I want to say it's possible they predate. I don't know if they predate the Justice Department exactly, or they're sort of simultaneous with the sort of original Justice Department. But because of the autonomy that they enjoy and have for a long time, they're referred to, or at least by themselves, as the Sovereign District of New York. So they also get to, it's almost like a TV, they hand you a TV contract along with your federal, employment forms to fill out. So. But I was on the civil side. I was not a federal prosecutor, so that nobody wants to hear from the guys who defend the Bureau of Prisons and the DEA when they get into car accidents and that sort of thing.
Did you try a lot of cases while you were there?
I tried a few. I don't know about a lot. I probably had about 8-10 trials, something like that, ranging from really short and small kind of tort cases. We defend all federal agencies in all kinds of FTCA cases and Bivens civil rights cases. So I had a case involving some federal prison guards. I defended my favorite, the most unusual, was defending the head of the CIA's technical services division, a guy named Sidney Gottlieb, about whom a biography was later written. And he was in charge of the CIA's program to experiment with LSD in the 50s and 60s and gave it to people unwittingly, really did some bad things. And this was a case brought by somebody who was convinced that they had been a victim of that testing program. So we had to defend him and defend that program to some degree. So that was interesting. But we also do, some of the trials are affirmative. So we do, in New York, the way the office is organized, we also do enforcement of civil rights cases. So I brought some voting rights cases and ADA case, things like that. Some cases under what then was a brand new law, the Freedom of Access to Clinic Entrances Act, against people who had barricaded themselves in a reproductive health clinic in Manhattan. So yeah, kind of both sides of the docket, and you do get some trial experience.
Yeah, and then you come back to Houston, I guess, and begin a private practice there.
Yeah.
Tell us a little bit about that. Were you a trial lawyer, just doing everything that came in the door, or
well,
like Lester and I do?
For a time, I worked at a plaintiff's side boutique for about 5 years or so, and then I went on my own and to handle appeals, because I really sort of decided. Although I very much like trials in the sense of, being in court and trying cases to juries, that's a lot of fun, and I enjoyed that a lot in the U.S. Attorney's Office. I don't miss, and already was sure I wouldn't miss, sort of everything that precedes, jury selection, I guess. The long life cycle of a case, all the discovery, the work with experts, that sort of thing I was never a huge fan of, and do like, legal research, do like writing. As you mentioned, and that's the source of the book, I'd been a appellate law clerk, and when I was in the U.S. Attorney's Office, I handled a lot of appeals, because you do your own appeals there. So I kind of decided that slice of practice was really more up my alley, I think.
You had a great, I looked at your website, and you had a great thing on there, which is probably certainly applicable to me, probably not Robin, but, Robin and I have argued a bunch of appeals too, although both of us are primarily trial lawyers. And you had this great thing on there about how, a trial lawyer probably really shouldn't argue a very important appeal, because it's a different audience out there. And I thought, he's very perceptive about that.
I mean, appellate lawyers sort of have to say that, of course, and justify our existences. And I do think it's true. Obviously, a lot of great trial lawyers are also really great writers and really great appellate lawyers. So it's not, the skills aren't at all mutually exclusive. But I think what you say is right. It is a different audience, and of course the most important part is not your 15 or 20 minutes of oral argument, but it's the written product, it's the briefing, and so the quality of the writing, and knowing how to achieve concision, and what's important and what isn't, and how to make something that otherwise can't help but being a little bit dry still lively, and want to be finished by your audience, who, you're writing for judges, and their stack of cases, after yours is a large one. So you want to hold their interest, and that's something of a discrete skill. So that's how we market ourselves. We have to say that.
I also noted that you've won appeals in the United States Supreme Court, where our last guest has argued, Craig Jones. He argued 2 times in front of the United States Supreme Court. I've never done it. And now it's so specialized. But tell us a little bit how that was.
Well, sure. And I have to say I haven't done it either, because the case that I won there was on the cert petition. And so it arose from a police shooting here in Houston. And that case, which I was not involved in at the trial level, got far along, but was then dismissed on summary judgment. Both on qualified immunity, but on both prongs of it. In other words, finding that there had been no violation, and then also that whatever law was applicable wasn't clearly established. So I handled that in the Fifth Circuit, and we lost. And it was an appeal from that the Supreme Court sort of sat on the petition for a long time, but ultimately granted it and reversed that dismissal without argument. So I'm disappointed not to get the argument, but very happy to win. But it would have been great to argue as well.
Yeah, and so now is your appellate practice all still civil cases? You don't do criminal appellate law?
I don't. Yeah, I really just do civil cases, and that runs the gamut from commercial cases to really any sort of civil case. It's mostly been, I would say, mostly a mix between commercial cases, tort cases, and civil rights and constitutional cases over the years. So a lot of each of those buckets, and then just the occasional odd, something else. But that's been the bulk of it, I would say.
And you're also a professor at, you're a law professor. How did you get into that? And tell us a little bit about that.
Yeah, sure. I teach two things at the University of Houston Law Center here in Houston. I teach a legal history course every other semester, which I'm only now doing. This semester is the second time I've done it, and it's just it's also a bit of an outgrowth from the book. It's really something I enjoy a lot, and it kind of runs from 1798 or so up to 2000, but as I tell the class, quite frankly, up front, I'm someone who's sprinting to the 20th century as fast as I can, because I'm really I'm not qualified I am to be covering the 19th century. That's stuff I know less well. So it's sort of overwhelmingly weighted to the 20th century, and it's a lot of civil liberties history and constitutional history more than anything else. It would cover a couple of other subjects like the growth of tort law after World War II and antitrust. We do touch on some other things, but it's mostly constitutional and civil rights history. And as I say to them, I don't want to be duplicating their con law class. So the goal really is to not so much focus on doctrine, although inevitably you do some of that, but more what's the social and political and economic background and history that gives rise to these cases. And after major decisions, what happens next? What's the fallout? That's really what we try to cover, more than really just here's a case and what was the holding and how is the doctrine changing. So that's a lot of fun. And the other thing I do there is I started and administer an appellate civil rights clinic. Again, kind of growing out of my interest in civil rights law and civil rights appeals. So it kind of functions both as a way to teach just appellate practice, but also, like any clinic, to work on real cases with the students. Very small. We just have 3 students each time, and so far. And we try to do one merits case where we're directly representing the appellant, and then also write an amicus brief. So that's also fairly new. Just the last couple of semesters I've done that.
Is there a student practice act or something like that in Texas? In Georgia, we have a student practice act where they can actually argue that we have clinics at our law schools. They can actually argue appeals in front of the Supreme Court and the Court of Appeals of Georgia.
That's terrific.
Also, 11th Circuit. We had a student argue in 11th Circuit.
Yeah, there's a similar arrangement here, and you in the 5th Circuit, you have to ask. You kind of have to file a motion and ask them to admit and allow to argue a student practitioner. But that's a history of that, and there's provision for that. So yeah, same thing. And that's part of what we're selling to students is come here and work on a real case, and you might get argument, as well.
I'm curious, how would you, because you're talking about the legal history and particularly 18th, 19th, 20th century legal history. I think about the Roosevelt, the court during the Roosevelt administration that threw out all the New Deal stuff, and then sort of, do you see, I'm not talking about necessarily ideology, but sort of from a contrarian point of view, the current Supreme Court being like that?
Yeah, very, very much so. I mean, I'd put it this way. I think what we're clearly experiencing is a constitutional revolution. And although to some degree it's a reaction, right? I mean, we're reverting to some degree and charting new territory, as well. But it's such a sea change that it is very similar to me to the 1930s, to the New Deal court that eventually ends the Lochner era. I mean, maybe I'm not sure. Maybe your question, man, is it like the Lochner era court in the sense that they're finding unconstitutional? It's a muscular, kind of aggressive set of
both, really.
Both. It has hallmarks of both, for sure. Yeah. I mean, the first class, when I first designed that legal history class, maybe 3 or 4 terms ago, but before I actually started teaching it, the first class was just going to be a kind of, we all get to know each other and talk about this kind of arcane, useless field of legal history and how, this would be fun for them because it's a lot like their undergraduate history, but it doesn't really matter. Certainly isn't going to affect your grade on your bar exam and doesn't matter otherwise. And of course, now that's completely changed. All of constitutional law is legal history, so in order to practice constitutional law, you kind of have to be an amateur legal historian or get a professional to help you out. So it's funny how it's become, what we say to them now is this is not academic anymore. This is constitutional law now rises and falls based on legal history.
Yeah, that's a whole nother podcast of whether I agree with that.
Yeah,
I have some thoughts about what our founders thought whether abortion was a protected right back when they wrote the Constitution. But we don't have to get into that. But Martin, first of all, we love authors, and we love authors who have written something legal, about a legal incident.
Yeah.
And your book is entitled Judgment and Mercy, The Turbulent Life and Times of the Judge Who Condemned the Rosenbergs. And it's a judge you obviously knew very well because you were his law clerk.
Yeah.
Tell us a little bit about how, were you thinking about that while you were clerking for him? Or is this just looking back and you think, wow, he's got a really interesting life. I'm going to write about that.
Yeah, no, it's very much the former of those two. But I have to preface that by saying my clerkship with him was really different and unusual because he died midway through my job. So I started working for him in August of 1991, and he died in February of 1992. And through the last half of that or so, he was declining in health and eventually stopped coming into the office. So I actually, I interacted with him and knew him, but much less so than almost anyone else, actually, who clerked for him over his 40 plus years on the bench. So I hope doesn't sound self-congratulatory to say that gave me more objectivity, I think, than I think it might have been possible to have for other clerks. And I say that because he was a person about whom clerks would have and did have really strong feelings. He was a really difficult boss, sort of tyrannical in a lot of ways, would yell at law clerks. A lot of law clerks quit over the years, which, as you know, is a really unusual thing. I mean, it's a one-year job, and part of the reason law students take it is how it's going to look on their resume and, the prestige of it. So you have every incentive to just however bad the conditions to just stick out the year and leave quietly, so to quit, especially in earlier years when he was a powerful and very well-known figure in the New York, at least the New York legal community and to some degree the United States. So that just kind of shows you how tough the conditions were sometimes. And I didn't see a lot of that. I saw a little at the beginning, and I kind of got some of the Kaufman treatment early on, but it was a faint echo, and he just didn't have the energy at that point any longer. So that did give me more distance, I think, to see him less like a mentor or someone who I really hated because the job had been so difficult, and more just someone at a greater remove. You mentioned, did I years later sort of think, is this somebody I wanted to write about? I thought really from, the incident in the funeral that I begin the book with, which was such an unusual thing. Almost from then I was thinking, I'd love to write a book about this guy. I think this guy is worth the book. His personality and his life have been so fascinating, well beyond this one famous case that everybody's heard of the case. But he did so much more in his legal life and his time on the bench, and just a truly kind of tragic family life. He's very, a lot of gray there, a lot of good, a lot of bad, and all kind of jumbled up together in this interesting package that made me think he really was worth a book. And in a way that, a lot of court of appeals judges, it's interesting to lawyers, but it might not travel beyond, their story might not appeal beyond lawyers. I thought his had some potential to, be interesting just to general readers.
So what was his pathway to the bench? What did he do to describe him? Tell us a little bit about his career.
Yeah. Well, you mentioned these former Southern District of New York Assistant U.S. attorneys who are on TV. He was like a very early version of that. He was a version of that from the 1930s. So his upbringing is very, classic rags to riches story, very much the Jewish immigrant experience in New York. His parents were immigrants. They'd only been in this country for 6 years when he was born. He's born on the Lower East Side of Manhattan, where, most Jews lived at the time. had no money. So his path to success was just racing through public schools. And he graduated high school early. He got to college, went to Fordham, and graduated a combined law school college program that was 5 years. So he got his law degree before he could even take the bar. He got his law degree before he turned 21, and he had to cool his heels for several months before he would even be eligible to take the bar. And in classic Kaufman fashion, he's not someone who let rules and procedures get in his way. So he tried to circumvent that by using a family or a friend connection to the chief judge of the Court of Appeals in New York, the highest judge in the New York state system, to get him to waive that requirement. And the answer came back, tell that kid to wait a little while. A few months waiting will do him good. And waiting is precisely the thing that he, had real trouble with. He's the kind of person who wanted everything done yesterday. And was incredibly efficient and incredibly energetic. So he works in private practice for 4 years. The lawyer he's working for ends up being his father-in-law. He ends up marrying the daughter of the boss. And he makes his way into the U.S. Attorney's Office, which was not easy because, they mostly hired from the Ivy League. So he was coming from Fordham. And he got in at just a perfect time because Roosevelt's new U.S. attorney there was a important Catholic lay leader in New York, and that person's second in command running the office had come from Fordham. And Kaufman had these Tammany Hall kind of Democratic machine connections, so he's able to get into the office in a way that some other students might have had some trouble with, or young lawyers would have had some trouble with. And that position really kind of makes his name. He handles these sort of widely reported, spectacular fraud cases that put him in the news. And he's sort of in the mold of, the New York, incorruptible New York City prosecutor, a little bit like Tom Dewey, who was becoming more famous at that time. So much so that Kaufman he's very young looking, had a kind of a baby face, kind of fleshy face. And his wife urged him to grow a Tom Dewey mustache so that he would look older for juries. And he decided not to, wisely. So that was his background. And then in the 1940s, he's a private sector lawyer, but he's representing people like himself, meaning he's not working at a white shoe firm. A lot of those firms didn't take Jewish lawyers back then. And he's representing up and coming Jewish entrepreneurial tycoon types. So he ends up representing the Newhouses in their growing publishing empire. He represents a hotel magnate, and his most famous client is Milton Berle, the comedian. And he quite savvily uses Milton Berle to cultivate these political connections with his main patrons are Tom Clark, who becomes Attorney General under Truman, and J. Edgar Hoover. So whenever he's in DC, he tries to get, tickets. If like Milton Berle's show is going to be there, or if they're going to come to New York, he'll try to, have Milton Berle headline a fundraiser. He's sort of using Milton Berle, actually. And he becomes a judge at age 39 in 1949. And he's widely reported then as the youngest judge in America. And that's wrong. It was Skelly Wright was a little bit like a few months younger. So he's the second youngest judge in America when he's appointed.
And then just reading a little bit about him, he sounds like, and as you've mentioned, he sounds like a very complex figure because he did a lot of good things, but then he did a lot of bad things too. And I don't know where you come down. Did you determine whether Judge Kaufman is a hero or a villain in your story?
Well, I think he's both. And that's why I find him so interesting. And that's true of most people, right? No one's all good and no one's all bad. And to me, the most interesting figures are the ones who are the most complex and the most difficult to kind of, ferret out, what their motivations were and what was good and what was the product of bad, selfishness and that sort of thing. So, so I think he's a lot of both. He did have he was really egotistical, he was really insecure, desperate to see his name in the newspaper. Over the years, he had a long-running relationship with the New York Times. So he's friends with the Sulzberger family, the publishers of the Times. He was friends with A.M. Rosenthal, the lead editor at one point. But the Times often put him in the paper. They covered him sort of far more extensively than you might expect. And that eventually got noticed. That was the cause of some complaint by reporters at the Times and some grumbling by his fellow judges. But, he desperately wanted that kind of public exposure and public stature. As I said, he's someone who sort of seemed to think at times that the rules didn't apply to him, that there was back channel maneuvering to be done, and he would do it. Of course, the most famous example of that is what transpired in the Rosenberg trial, where he had ex parte conversations with members of the prosecution team.
Which is generally frowned upon.
Generally frowned upon. Now, I will say, I know that's a joke when you say that, because what you mean is it's absolutely, grotesquely unethical and prohibited, and that is true. And I spent some time arguing that in the book, but I feel like the reason it required the argument in the book is because it had been said and admittedly, this is by Roy Cohn, who's a dubious source, but Roy Cohn had written in his autobiography before he died that a lot of judges did that. And I don't think back in that day, in that era, when it was less formal, and I don't think that's wrong, really. And some other, some law clerks of Kaufman from that era, including one who went on to be a real pillar of the New York criminal defense bar, sort of agreed with that some other judges might have done that too. The relationship between the bench and the U.S. Attorney's Office was very cozy. It was a system where the system that, was there when I was an assistant U.S. attorney in the 1990s, where you file a case and it's, wheeled out to a random judge. They didn't have that system in the 40s and 50s. They worked the way some state courts still work, where they had trial parts and motion parts and, special other parts that handle. So in other words, a case didn't stick with one judge. It kind of rotated through the system and would be assigned to a different judge for trial. And as a result of that, the head of the U.S. Attorney's Office, not the U.S. Attorney himself, but the lead executive, would just kind of go and talk to some of the judges and see, who's free and who wants this case. And we got this case coming up and it's probably going to get here in October. And is that going to be you? You're going to be in the trial part in October. It was much less formalized. And Kaufman had been a creature of federal law enforcement, this protege of, as I said, Hoover and Clark. And I think he just thought that, those institutions are above reproach, and it's natural for a judge to be talking to the United States Attorney's Office or the Justice Department, and of course that wouldn't compromise my fairness. I think that's, if forced to kind of defend this, which he never was, in the sense that he never commented on the controversy when it became public in the 1970s. I assume that's kind of what he would say.
I do think
a lot of people would say that unless you're the defendant.
Yeah, of course.
And I think I will say this, I do think that it's become more and more taboo, coming forward. I defend a lot of judges that get caught up in ethical charges, and it's in almost every one of them. Somebody says they had, ex parte communication. I think the one phrase I had never heard till I read Fall of the House of Zeus, which was about Dickie Scruggs. In Mississippi, they have their own term for it. It's called earwigging. And it's when you kind of go and, talk to the judge in general terms, earwigging. So,
yeah. Well, I mean, look, we're all familiar with, in smaller locales and in state court, where these are elected officials and there's so much, socializing and clubbiness and familiarity between the bench and the bar, it's less surprising. This is supposed to be the kind of most, the longest standing federal district in New York, and obviously one with, a sort of an elite bar, or so it thinks. It's a little surprising to find that there, but I do not mean to say that every judge did it, and this is just my guess. I don't know that any other judge really did it. I just got the sense from the people I interviewed that Cohn probably was not completely wrong about that. But having said that, it would not be accurate to say that, the legal prohibition on it or the ethical prohibition on it then was not yet fully defined or hazy. That's not true. There were longstanding already codes governing judicial behavior and certainly lawyer behavior prohibiting that, and that had been true for decades. And it's not hard to find cases long before 1951, when the Rosenberg trial happened, overturning decisions on the basis of unethical ex parte context. So it was clearly prohibited.
Let's talk a little bit about his most famous case, the Rosenberg case. But you have already mentioned a famous event that occurred. I was wondering, were you at Judge Kaufman's funeral?
Yes. So I was at the funeral.
And so you saw that incident occur.
Yes, that's right. So the incident you're referring to happened at his funeral, and I was there, and we're sitting. It was in the Park Avenue Synagogue on the Upper East Side of Manhattan. It's a crowded sanctuary.
Packed.
It's packed. As I say in the book, there are I was doing a lot of people watching. There are all these other judges there. The head of the former, I think, William Webster, who had been head of the FBI and I think was then later head of the CIA, or I may have that backward, but he was there. And just, like a pretty prominent crowd, as you would expect, and police officers there, security. So we're sitting in back, and the rabbi's up there giving the eulogy, and what I hear from behind me is somebody shouts, somebody bellows, he murdered the Rosenbergs, let him rot in hell. And people, it's hard to do justice to what that was like in the moment, because it felt like a gun went off or a bomb had gone. People ducked. It was so shocking. And the guy, I guess he yelled so loud that it took a millisecond to register what that sound was. And it was a person screaming. And you figured it out, and you turned around, and he was a sort of shabby figure who police immediately kind of converged on him, and he left the sanctuary. So the rabbi, was stunned, and took a second to sort of recover himself and pick back up, and people couldn't believe it. Out after the service, out on the sidewalk, there were 2 or 3 people, and it was freezing day. This is like early February, cold day, and people out there picketing with signs about the Rosenberg, and that just blew my mind. I couldn't believe. Of course, I knew about the case. I knew about his role in the case. I knew about the controversy. What was so stunning to me was that it was still such a present, alive thing for people that would motivate them to somehow find out where his funeral was going to be. This is before I don't think the obituary had been printed yet. I'm not sure they knew even. Maybe that day the obituary. I don't know. But they found his funeral, and they protested his funeral. And so just this, this phrase we have of from beyond the grave, or like haunted to the grave, like in his case, it was literally true, basically. So that was so stunning. And it was one of the things that made me think, this is kind of worth a book, I thought.
Tell us a little bit about the Rosenberg case. What is it that Judge Kaufman did that brings out such animosity about it?
Sure. Well, they were arrested and tried for espionage. Julius Rosenberg was arrested first in 1950, and then months went by, and Ethel Rosenberg wasn't arrested. She was arrested almost on the eve of trial, a couple months before trial. And the leading theory on that is that was really done to pressure him to confess, and they had almost no evidence against Ethel Rosenberg. The thing that led them to Julius Rosenberg, if you take it back several steps, was that the United States had broken the Soviets' code during World War II in an intelligence operation called Project Venona. So they knew that this espionage ring existed in the United States, and they eventually found Klaus Fuchs, who was a German physicist in Britain who'd worked on the Los Alamos project, who has a cameo, sort of a brief appearance in the recent movie Oppenheimer. And he was the kind of leading figure in it who transmitted by far the most important information to Russia about the bomb. But another person in this ring was Ethel Rosenberg's brother, David Greenglass, who was a sort of low-level machinist without much scientific education, really. But he found himself assigned to Los Alamos, and he came back with information about what was going on there during the war, and a kind of crude sketch of one of the components of the bomb that was passed to the Soviets in that and other information in 44 and 45. So eventually the FBI cracks all of that, arrests Greenglass. That Greenglass leads them to Julius Rosenberg, and he's arrested as well. They're tried in 1951, shortly after the beginning of the Korean War. It's the worst possible time for anybody to be tried for conveying secrets to the Soviet Union. And one of the sort of lines of defense they try in a not so effective way to articulate is that, look, in 1944 and 1945, Russia was an ally. And things were very different, but they're kind of stuck with this fact that the international climate has changed so radically, and now nobody has any sympathy for information conveyed to the Soviet Union. Their trial's entirely one-sided. The only witnesses they call are themselves. They do a poor job in front of the jury. And their lawyers are not seasoned criminal defense lawyers, but Communist Party lawyers that were, I think, provided to them by the party. And the government has a pretty good case, the key witness being David Greenglass. And he talks about Julius's espionage, as do some other witnesses. He's the only witness against Ethel. And he's the evidence against Ethel that he provides the jury is that she typed up his notes from Los Alamos so that they'd be intelligible to the Russians. That's what puts her in the conspiracy. That's her overt act. So you ask about Judge Kaufman. He's the trial judge. He's presiding at trial. And the two main lines of criticism of him over the years about the trial are that he intervened a ton in questioning. And if you read the transcript, it's pretty one-sided. It appears that way to me anyway, and I think most observers think so. He really is it seems like he's putting a thumb on the scale in favor of the government. And what kind of jumps off the page is that he believes their case and thinks they're guilty. So that's part of it. And then there's a lot of attention focused on the sentences. The sentences are so draconian. I mentioned Klaus Fuchs. Klaus Fuchs only received 14 years in prison in England. He's a far more important figure. Now, it's true that's under different law, and that was the maximum sentence he could get, and he cooperated. So, it's apples and oranges. But the sentences for the Rosenbergs were so severe, and the thinking by a lot of people was that this was really intended to get them to confess, that he sort of over-sentenced them in the hopes that they would cough up names of others who were spying. And after Ethel is executed, one of the high officials in the Atomic Energy Commission, later told a New York Times reporter, many years later, he was writing his book about the case, she called our bluff. They never did confess and weren't going to confess. So that was the nature of the case.
Was there a point where Judge Kaufman could commute the sentence of Ethel and not have her executed?
Yeah, absolutely.
But he showed no mercy. Unlike the name of your book,
right.
He did not show mercy.
Right, that's right. He could have done that. I should also point out that it was a very odd sentencing scheme under the Espionage Act. Life in prison was not a possibility. So the choices were death or 30 years. And he well knew that in that time in the federal system, unlike today, there was a lot of probation and parole in the federal system then. So 30 years commonly would not be 30 years. It'd probably be more like 20 or 15, something of that nature. So it did present him with this sort of unusual and odd choice of extremely severe and then more moderate with nothing in between. He could have commuted the sentences. In fact, under the law at that time, the Rosenbergs had no choice but to go back to him to get him to reduce the sentence after they exhausted their first line of appeals. In other words, the Court of Appeals and the Supreme Court would not, touch the sentence. The trial judge then had almost unlimited discretion over the sentence, and he was the only person who could reduce it. And so they made an application to him in late 1952, and there was oral argument, in his court, and he rejected that. So he was not moved.
The folks who were so upset about what happened to the Rosenbergs, were they so upset because of the sentencing of execution, death sentence, or were they upset because they really thought the Rosenbergs were innocent? Yeah,
well, there really were two. I think both is the answer.
Okay,
but not always both together. So back in 1951, 52, and 53, there was widespread belief in their guilt. That very few people really thought they were innocent, and so a lot of the controversy that gradually built up about their sentences prior to their executions, and there were demonstrations around the United States, and there were a lot of demonstrations in Washington, and something like 20,000 people were there in Union Square in New York the day they were executed. So a movement did kind of grow up not just in the United States, but around the world. The Pope expressed interest in clemency. Picasso went on record saying he thought the sentences were unjust. Figures like that around the world weighed in on the Rosenberg case. And almost all of that was that the sentences were too harsh. And some of it self-interested on the part of the United States, in the sense that we were just making martyrs for international communism. And this in the end would sort of defeat the purpose of advancing American ideals around the world in this kind of battle of ideas with communism. Later, in the 1960s and the 1970s, a kind of different movement grew up around the case, and that was led by the Rosenbergs' own children. They had two children who, at the time of the execution, were, I think, 10 and 8 or 8 or 6, something like that, under 10 years old, young children. By the late 60s and 70s, they are now in their 20s, and they had been living under a different name, Meerpol. That was the name of a family that took them in and raised them. So they kind of went public, basically, with their identities and with their views about the case. And they wanted to show that their parents not just had been sentenced harshly, but that they had been framed by the government. A book came out that kind of helped their cause in 1965 called Invitation to an Inquest, written by two freelance science writers who really dove deeply into the evidence and picked apart the case and tried to make the case that the FBI had manufactured a lot of the evidence that convicted them. And by the time the Rosenberg's kids are trying to make this argument publicly in the early 70s, it's like post-Vietnam, or Vietnam is winding down. It soon becomes post-Watergate. And so this idea that the government might, lie and create fake evidence and spy on people, that's much more in the culture than it ever would have been in 1952 and 1953. So that argument kind of falls on much more receptive ears among new left activists and just liberals around the country. We now know that isn't true. We now know that Julius Rosenberg was, in fact, a spy. The jury is very much out still, all these decades later, on Ethel and whether she participated. There's really no evidence that she did.
So we've all probably appeared in front of a judge or two that was often wrong, but never in doubt. And how would you characterize what his response would have been to the protesters, or to the guy that yells from the back of the synagogue at his funeral? If he could have had a voice then, what do you posit his response might have been?
Yeah, well, he did have an energetic response up until not at that memorial service, but right up until the end. So a lot of this came out in the 1970s. As I said, the kids were leading this charge, and the kids also filed a very early FOIA request. And so evidence of his ex parte contacts, which appeared in some FBI documents, became public in the 1970s. And he was really, he was dogged by these protesters. They would show up at his speeches. He'd already been the subject of bomb threats back in the early 50s. Those kind of ramped back up again. There were calls for his impeachment. There were op-eds about the case, open letters in the New York Times urging him to open his files. Over 100 law professors signed a letter that they sent to the House Judiciary Committee urging examination of the case. So all of that was happening, and his way of responding was to enlist allies and friends in the bar, and this is often true today with judges who were under attack for one reason or another. His lead defender was Simon Rifkin, who had been a federal judge briefly, and Kaufman was very close friends of his. Rifkin is of the firm Paul Weiss, Rifkin and Garrison, very prominent New York lawyer. Rifkin was probably the public face of his defense. Rifkin would write op-ed pieces defending Judge Kaufman. Other members of the bar would do the same. Other judges would try to come to his defense. But it was never terribly effective, in part because this kind of campaign by the establishment, it sort of looked old and stodgy and fusty, when compared to these younger activists who had sort of the culture and the temper of the times on their side, I think. And it really troubled Judge Kaufman over the years, and no response, no sort of provocation anywhere out in the world was too minor to sort of escape his attention. So there's a ton of correspondence between him and the FBI. He would try to enlist the FBI to help him. If there's an article somewhere or a play came out about the case in the 1960s, all these memos went back and forth between FBI agents based on Judge Kaufman's calls to J. Edgar Hoover. So he couldn't let it go. He's not someone who could rise above. And he tried behind the scenes to organize this public defense.
As a Southerner, I clerked for a federal judge. I didn't find out about it till I was 48 years old, because that's when he became a federal judge. I worked for him when he was in private practice. But he wrote a book about Waties Waring, who was the judge in the Briggs versus Elliott, which was later Brown versus Board of Education from South Carolina, and wrote the eloquent, dissent, for that, and was basically ridden out of Charleston, South Carolina on a rail, died in New York City because they were more accepting, of him. So it's interesting to me. And I think that case was about 1951, as well. Yeah. So it's just interesting to hear how these judges react to these cultural upheavals, really, as you have in the title of the book.
Yeah, Kaufman became, in a lot of circles in New York, he became a sort of pariah. And he was not someone who was going to do the reverse and move to South Carolina. So he had nowhere to go. And he cared very much about elite opinion of him, on the Upper East Side and in the New York Times. And so I think it was awfully wounding. And he kind of fought back the best he could, and he fought back as vigorously as he could while publicly, maintaining a facade of sort of, silence. But he was active in his own defense. It just wasn't all that successful, really.
Well, after the Rosenberg case, he had several other cases that did show he was a bit of a progressive, I guess. I don't know if that may be too strong of a word to use. But
no, it's not.
Okay, some really interesting decisions come out on a variety of topics. But the first one I was just going to mention was the U.S. v. Mazzei. Mazzei. And that involves a man named Ignaz Mazzei. Yeah. Can you tell us just a little bit about that case and why it was so important? And how Judge Kaufman seems to totally flip on us.
Right. And that's early on. I mean, Judge Kaufman doesn't become a really sort of, prominent and well-known progressive when he's on the Court of Appeals, and that's in the 60s, 70s, and 80s. This is very early. He's still a trial judge. And this, I think, has to be chalked up, unlike his sort of later evolution, which really was an evolution. This, I think, is at the same time as the Rosenberg case, basically, and it has to be chalked up to his sympathy for immigrants, which some clerks sort of talked to me about. It came up again in the John Lennon case when he was on the Court of Appeals. He never really lost his sympathy for immigrants coming himself from an immigrant family. Mazzei was a guy who he'd been in the United States. He went back to Hungary, which is where his family was from. He was trying to get back into the United States after a trip to Hungary. And this is when Hungary's behind the Iron Curtain. And he suspected, although the government doesn't really come out and say it very much, he's suspected of being a communist, and they will not readmit him. So he's stranded. He has nowhere to go. He's stranded on Ellis Island. And the government tries to find, not unlike people at Guantanamo these days, the government tries to find a third country that'll take him in. Nobody, not surprisingly, nobody wants this kind of suspected communist who won't be readmitted to the government. So he's just stuck there. And the press takes to calling him the man without a country. And the case lands in Judge Kaufman's court, and he says that, no, this guy has due process. He's here at a port of entry, and a port of entry is the United States. And, the Constitution refers to persons, not citizens, when it comes to 14th Amendment and the 5th Amendment. And he should get due process. And that case goes to the U.S. Supreme Court, and he's overruled. And the opinion's written by his old mentor, Tom Clark. And the gist of that opinion, which, as I mentioned, Guantanamo, the opinion is cited in Guantanamo era decisions of the last 20 years. That opinion essentially says that, the president has almost absolute power over aliens. Certainly the government relied on Guantanamo. It just, some of those holdings give people at Guantanamo habeas corpus rights, but it is still a live precedent that the government uses, and Judge Kaufman was on the other side of that. So it's an interesting case.
And then you mentioned the John Lennon case, which I'm not sure I even knew about. John Lennon trying to be kicked out of the United States, but you want to tell us about that? Yeah, sure.
John Lennon. So John Lennon decides in 1971 that he's going to go around the country and hold some concerts to try to get the youth vote up. And so 1972 is going to be the first election of 18-year-olds voting in the presidential race. So that gets that grabs the attention of the Nixon administration. And speaking of South Carolina, Strom Thurmond, who writes a letter to John Mitchell, Nixon's attorney general, and says, like, can we do something about this? Like, what can we do about this? So they decide, Lennon had been here on a series of visas that were just kind of routinely extended, like visas for people working here, basically. They decide that actually he's ineligible to be in the United States because of a drug conviction in England. He had pled either guilty or some version of no contest in England to a drug possession charge there because his lawyers had told him to. It had no real effect on his life, so he just did that to make that case go away, and that was dredged up by the Nixon administration to deport him. And suddenly, his routine visa application is denied, and he's now faced with the prospect of having to leave the country. So he had a very good lawyer, quite as you would expect, a resourceful lawyer who immediately demands, the equivalent of discovery from the government, and sort of goes on offense, and they conduct a public relations campaign. It's very effective. And it gets to the Court of Appeals. And basically it's one of those cases where we all know judges like this, where Judge Kaufman tells the clerk, like, this is not going to stand, go find a reason. I'm telling you the result, you go get me the reasoning. And he had a very, very good clerk then. And what they came up with was that the British conviction would not sort of satisfy American standards of due process. And that's because it was almost like a strict liability standard in England. In other words, if you had the drugs, no defense such as, oh, it was my friends, or I didn't know these were illegal, or I didn't know, what they were, that kind of defense, which you might mount to a criminal charge here, was effectively disallowed by British law. And so the notion
was scienter allowed.
Yeah, it's that scienter. The scienter was what it was. And so the idea was that, under immigration law at the time, we were only going to honor a conviction that met, there was an out for convictions that didn't meet American due process standards. And that's what they argued. And that it also had the virtue of being a sort of, it's almost like a, queen for a day, get out of jail card for one person, because this would not have any kind of broad effect on the drug laws here or even on immigration law. It was such an unusual circumstance that also appealed to Kaufman, because he said something to the clerk along the lines of, well, we don't want like everybody on drugs this isn't going to be a free pass for all the drug addicts, is sort of what he was saying. But let's find a way to let John Lennon stay here.
But I like the Beatles, so let's let him stay.
Well, he didn't. He knew. I think it's safe to say he knew nothing about the Beatles, and I say that because the reason I say that is because his in-laws, a few years earlier, his in-laws had given him a birthday present, and I only know about that because the thank you card he wrote from his office is in his papers in the Library of Congress. So I ran across that, and in his thank you card to his in-laws, he said, thanks for the gift. I look forward to getting to know the Beatles this summer, or at least one of them. So I don't think he fully understood it was a band, and it's not. I doubt he ever listened to him.
So it strikes me too that he was on the district court and then went up to the Second Circuit, and I know like confirmations were a totally different thing back then. But did the Rosenberg case or any of the other cases did it have any effect whatsoever on his confirmation ability to get confirmed?
It did. It's a really good question, and it did not, but not at all in the way that we would expect today, in the sense that it would be high profile hearings or an advertising campaign, millions of dollars raised. Nothing like that. In the 1950s, he was already seeking, angling behind the scenes to get himself elevated to the Second Circuit, and his backers were doing the same. And that attempt at promotion for him was seen, and his backers kind of made the case overtly, we should reward him for the Rosenberg case. He was under pressure then, all the bomb threats. He had to leave his apartment. He's been reviled in the communist press and then in some quarters in the liberal press in the United States. We have to stand up for him and show that, he just did his duty under difficult circumstances. One of the people who found that revolting was Felix Frankfurter, who proved decisive in preventing Kaufman from being confirmed during the late 50s in the Eisenhower administration. And that was going to be unusual because Kaufman was clearly a Democrat. And the Eisenhower administration was trying to fill judgeships with Republicans because they hadn't had a Republican president since 1932 was the last time. So they were desperately trying to put some Republicans on the courts. But even so, they were thinking about Kaufman because some of his backers were conservatives who approved of the Rosenberg case. So at the last minute, a couple of vacancies opened up, and at the last minute, Frankfurter went to Herbert Brownell in the Eisenhower administration and basically said, it's written in a letter he sent to Learned Hand. I despise a judge who would say that God told him to impose a death sentence. And that reference to God was because when Kaufman was deliberating over the sentences, he kind of let it be known to reporters that he was meditating alone in his synagogue. That was a story he kind of let slip out there.
Well, that to me is one of the interesting aspects, because the I guess Julius Rosenberg at least was the son of Jewish immigrants, correct?
Yes.
As was Kaufman.
As was Ethel, sure.
And because now in this day and time, there's a tweet about the ethnicity of one judge or another from a certain former president of the United States. That issue comes up.
Yeah.
Was that ever in any way a factor, do you think?
Yes, absolutely. So an early line of criticism of him, right, very shortly after the sentences, just as some public opposition was beginning to coalesce about whether the sentences had been too harsh, an early line of criticism was that he had bent over backwards to be harsh against the Rosenbergs to prove this Jewish American loyalty, to prove that Jews could judge other Jews and we were just as loyal as anybody else. And I think there's truth to that. I think deeper than that was Kaufman's feeling that these were people who were on trial who were very much like him. They'd grown up poor immigrant Jewish families, Lower East Side. Julius his family had been in Harlem, which was a kind of center of Jewish settlement for a while, as Judge Kaufman had lived in Harlem as a high school student. So he'd been there too. But whereas Judge Kaufman believed so thoroughly in the American dream and the promise of America and how it was a sort of promised land for American Jews, he saw the Rosenbergs as traitors, not, I think, just to the United States, but really almost to him and to the Jewish community and to what we had achieved and accomplished, in this country. So that was very much in his mind. And you mentioned him, and we've talked about the Rosenbergs. The prosecutors were Jewish. Roy Cohn was one of the leading prosecutors. The U.S. attorney who was there personally prosecuting the case, Irving Sapol, he was Jewish. So, there were articles saying, look, some people are going to say, look at these Jews who were communists, like the Rosenbergs, and that was a common anti-Semitic sort of line of attack that Jews were typically communists, and so many communists had been Jews, and they kind of fused the two. And so this article said, critics will say, look, more Jews who were communists, but they should pay attention to the judge who was Jewish, and the prosecutors were Jewish. Those were kind of defense of Jewish loyalty in that article. I think all of that was swirling around in Kaufman's head for sure.
Do you think that led to him, because you talked about, for example, with John Lennon, okay, this immigrant's going to stay. Go find a way for this to happen. Do you think he bent over backwards on some of those cases where he had an experience to sort of make up for, or was that's really the leading, that was sort of the leading theory that was something that motivated me to want to write this book. I mean, the idea about Kaufman was that all of his liberalism in the 60s and 70s and 80s was atonement for the Rosenberg episode, and either that was either meant in a cynical sense that he was atoning. Probably he wanted people to see that he was liberal so that they would
publicly forgive him, and that, the cynical view of that is it was all kind of an act, and he just wanted to remain in the good graces of the New York Times and his friends on the Upper East Side. Or there was a more sincere version, which is he really genuinely did feel bad for what he'd done as he grew older and as time went by, and he kind of reacted by becoming more liberal. I do think it's true that he cared about his image, and he liked his image as a progressive for sure. I mentioned this protesting of him in the 1970s. One example of that was he was going to give a commencement speech at Pomona College, very much like stuff that happens now. And word got up to the administration there that if he came and he did that, there would be protests and students would walk out. And he was kind of very quietly, more or less, asked not to come, and he didn't. But he wrote a piece about it in the New York Times Magazine entitled "A Free Speech for the Class of '75." And in that article, it's the only place where he really publicly addressed the Rosenberg controversy. And in that article, he touts all of his liberal decisions. And he says, Bob, he said, in essence, I'm still being attacked for a decision made before these college students were alive, were born, many of them. So that kind of linked, in the public mind, and it seemed linked in his own mind, his liberalism to the earlier Rosenberg case. But having said that, I think his inclinations were progressive to begin with. Growing up in the family he grew up in, being a kind of Truman Democrat who believed in the power of the state to make people's lives better, being, it's almost always favoring immigrants. As one of his law clerks I interviewed put it to me, he really liked these like David versus Goliath kinds of cases. And he was a kind of David supporter from the beginning, I think. So I don't think it was all atonement, really.
After writing the book, and obviously you've done so much research, going back and reading the trial transcripts and basically everything he ever wrote, do you like him more or like him less?
No, I like him. I guess I like him more. Do I like him more or less? That's a great question. I like him more. I mean, I think he's a sort of tortured figure, who did a lot of good, whose impulses and inclinations later in his career were right. To my mind, they're right. And admittedly, I'm sort of ideologically in sympathy with his side of the ledger. I think, he was, as I said, he was extremely active. So a lot of people would have, as time went on, they would have just sort of kicked back and settled into the comfortable life of an appellate judge. He did all this stuff extrajudicially that was extremely important. He served on a committee that revamped standards for juvenile justice. That was like a 10-year project that produced, I think, 20 plus volumes of standards in conjunction with the American Bar Association and the IJA. Which became kind of influential. He did projects he changed the jury system, which had been, places had, instead of selection from things like voter rolls and driver's license rolls, things that make, more broadly, make jury service more broadly open. Previously, there had been a lot of jurisdictions had used what's called the key man system, where the person in court, the clerk responsible for rounding up juries, basically just called their friends. He was on a committee that kind of exposed that practice and got it changed in a lot of jurisdictions. The thing that certainly he wasn't well known for publicly, but really endeared him to me the most, was this committee he served on in the late 70s and early 80s to increase judicial pay and judicial pensions. And it sounds kind of boring and in the weeds, but survivors' benefits in particular were almost non-existent. And judges really used to quit over that. And he was someone who was quite well off. He didn't need the survivors' benefits, and he didn't need even a higher salary. But he worked tirelessly on that and lobbied, in the way that he always would, which is, energetically. He lobbied Congress. He called reporters. He didn't just sit there and kind of oversee a report. He really worked on it. And he would joke that it was a thankless task. And it's funny because it was just the reverse. His files are bulging from that period with letters from federal judges all over America who he didn't previously know, thanking him. And not just in a kind of generic way, like everybody likes the higher pay, but sob stories of, disabled dependents who were not going to, if they were to die, then who was going to provide for their kids? People unable to send their kids to college. I mean, real some of them really heartrending, actually. And that's something he did just because he believed in the value of the federal judiciary, and he didn't need it personally. So, yeah, there are a lot of things like that kind of form my ultimate view, I guess. I think a lot of, the Rosenberg case, a lot of that was his ambition. He's very young at the time. He wants promotion. He's angling for the Supreme Court. I think that by the time he achieved some distance and some perspective, he changed a little. He was always image conscious and always, almost hyperactive, but I think he'd had some perspective.
So, we have, sort of in that era, it seemed if you wanted that promotion, if you wanted to move forward, that, the folks who sort of got that, if they wanted it, was the sort of what I would call the trial lawyer politician, folks that knew a lot of folks. They were, had a great network. They had been in court a lot. And so now we see a lot of judges, and I think Robin and I have similar opinions on this, that never tried a case. I've been, I was on law review at an Ivy League school, and I clerked for, everybody from a magistrate court judge to a U.S. Supreme Court justice. So at 39, maybe, I'm ready to go be a judge. And I'm wondering if, because you've been in academia, you've tried cases, you've done a little bit of all of that. And then you've followed the career of this guy who's really, he wasn't in the tradition of Robert H. Jackson or Hugo Black or even Lewis Powell, who was sort of a big firm, trial lawyer. Which do you think is better preparation for being a judge?
Wow, that's also a great question. I mean, he certainly, I think, better preparation for being a trial judge is to have been a trial lawyer. And right, every now and then these days we read about someone who's appointed and they've not really tried a case or had experience in trial courts, and it's mind-boggling to me that they would be put in that position, of suddenly becoming a district judge, and at some level it's even mind-boggling to me that they'd want it, because it would be such terra incognita, if you hadn't practiced there. Obviously, or one can assume part of the reason they want it is as a stepping stone to, the Court of Appeals. The strictly academic background, and having clerked, let's say, at a higher court fits, an appellate judge job a little bit better. But even there, I certainly would agree, I think with you, I'm guessing, that even there, better preparation would be to have had some experience in the trial court, so that by the time you're looking at, what the parties claim is error, you understand what it was like to have presided at a trial and what that would have been like in the moment, and how important it is, because often it feels and is very, it's the importance level is very different when you're there as opposed to what it might look like on the page. So yeah, I'm very much a believer in we ought to be rewarding experience, rather than simply credentials or, political ideology. And he is someone, that's a great term you use, like lawyer politician. That's absolutely what he was. He knew everybody. He'd done fundraising for the Democratic Party, had all these connections. He knew the other judges. He just up and down lists, both legal and political, he was connected. And there's, how else would you get appointed at 39, right? Like in that era when you couldn't really, do what some of these people have done now.
Yeah. Very, very interesting. I think it's a fantastic book, and so glad you've written it. Let me ask you this, Martin. If a person wants to write a book, what would your advice, now that you've published this one, what would your advice be to someone who wants to write a book?
Yeah, is this person sane or not sane? Or I don't know.
I always hear it's very hard writing a book. Is that true?
How secure are their retirement accounts? That's a question I might ask too. Look, I would absolutely say do it. What other advice would I give? Right? Like,
you did it.
Yeah, I did it. And crazy or not, I did it. And I did enjoy the process a lot. It's something I've been thinking about forever. And I did it. I have to say, I did it over the years in dribs and drabs. I mean, I started working on this in 1994, and whenever I had time in between jobs, I would do a little work on it. I went through period, where I wanted to be one of those people who could wake up at 5 a.m. and, do a couple hours of work on it before I then did legal work. And that lasted about 3 months. I gave that up.
The John Grisham method,
Yeah, I was younger then. That seemed like a good idea. And even then it petered out pretty quickly. So, and, other times when my practice wasn't as busy. So I did work on it over the years, but then I got to around 2015, 2016 or so and realized like I just was not going to finish this unless I devoted full time to it. I'm someone who I don't do as well with 15 balls in the air. I'm much better with just, if I could focus on one thing, then I feel like I'm getting something done. And so I did take, 2-3 years or so as a kind of sabbatical to finish this. And yeah, I mean, as advice for other lawyers who want to do something like that, does it take a toll on your practice and your finances? Yes, it does. Inevitably it does. But I think well worth it if it's something it's something you're really interested in and something you really thought about for a long time, and you feel like that's the only way it's really going to come to fruition. Then life's not just about how many cases you've had, right? And 2 or 3 more years in practice. I mean, do something different. I'm a believer in it for sure.
Do you have a favorite book that motivated you or inspired you?
Wow. No, I wouldn't. I don't know that I had one book. I mean, I grew up, my father was a history professor. So that's no doubt part of this too, is I always, I grew up reading a lot of history and a lot of historical fiction. Like probably the first adult level kinds of books I read were historical fiction, a lot of James Michener, books in that vein. My dad I have a couple of brothers who are also lawyers, and I think he was like kind of subtly trying to direct us away from academia and into something a little more remunerative like law. And so he would, I remember him saying, look, if you want to write history, you're interested in history, you want to write history, you can do that. You don't have to be a professional historian. And he would talk about authors like Barbara Tuchman and, popular writers of popular history who weren't academics necessarily. And I kind of took that to heart. This book is sort of the answer to him saying that all these years ago. So I don't know any one book. I love All the King's Men. That hit me in college really hard, and that's about, to some degree, about lawyers and about politics and about law.
So you know the quote then, don't you?
Wow, which one? I don't know.
The quote from the stench of the deity to the stench of the Stroud, there is always something. I used to could do it better than I can now.
No, that's
but
been
it's
a while.
About how you can always dig up dirt.
Right.
It's
right.
From All the King's Men.
Yeah. Well, like so many of the themes there, the sort of political intrigue and back channel stuff and public politics and private politics and law. Like I feel like a lot of that's present in this story and about this judge. So some of that was on my mind, but that might be as close as I could come to a single book, I guess.
Now that you've published the Judgment or Mercy, what's your next book?
I don't know. I may have to. I'm going to try to get an advance for this next one, and I may need an advance to write a next one. So I'm not sure. I would love to do it again. I absolutely would love to do it again. Maybe not a full scale, birth to death kind of biography, but I do love, this genre of nonfiction about law that homes in on a particular case, and that case becomes a vehicle to talk about all the personalities in the case and whatever the social or economic or political stuff is that gave rise to the case. That kind of, and it could be a historical case or something current. That kind of writing I like a lot, and I could see, and it's also a little more confined as a subject. I could see doing that. I mean, in doing this, I really got, what was most interesting to me in a way, after a while anyway, it became less his story and more the story of some of these individual cases, which were just fascinating to me. And there are, digressions a bit in the book that that can't go on forever. You have to kind of cabin them. And my editor wanted me to cabin them even further. But, that, for example, that case you mentioned, I think you mentioned the desegregation case, maybe you didn't, the desegregation case in the North. He presided over the first school desegregation trial from New Rochelle, New York. And the main civil rights lawyer who was handling that became like super interesting to me, and that whole story. Yeah, that's almost a book in itself, I think, or could support a book in itself. So yeah, maybe something like that.
I think that whole era, sort of from the 50s through the 70s up to the Watergate era, in some ways was just sort of the golden age of trials. One of the books I just loved was The Man to See, which was about Edward Bennett Williams, and covered all his trials. And of course, now we get Johnny Depp and Amber Heard, and that kind of thing.
Yeah, that's pathetic. Yeah, no, I mean, right? These larger than life figures, super colorful trial lawyers. That's really interesting. And there were cases I ran across in this book that were just, the facts of them and the people involved were fascinating. The legal rule, that's, as a lawyer, you either are or aren't interested in that, or can make it, interesting, or try to explain what its current relevance, if any, still is. But the stories, those hold appeal, I think.
Well, we'll be looking forward to your next book.
Oh, thank you. If there is such a thing, I'd love to come back.
Absolutely. We really enjoyed talking with you, and I think I let you know this, that we ask our guests the same last question. Every guest.
Yeah.
How do you define justice?
Yeah, you did let me know that, and therefore I should have a much better answer than I do. Having been given some advance warning, I don't have a great answer. When I saw that that's the question you end the podcast with, all that really came to mind is that I would answer it sort of the way I think Judge Kaufman would answer it. And he did write a bit in the 80s, especially toward the end of his life, about the process of being a judge and what you should take into account. And in part, he wrote it because that was a rising era of conservative legal thought and the beginnings of originalism, the premise of which is the personal life of the judge doesn't matter. All that matters is, what was the intent of this provision as it existed then? What do the words mean? And if the answer there is clear, then full stop. And at most, we might see, what did they intend when they wrote it? But nothing else matters, not contemporary life, not evolution, the evolution of legal philosophy or legal ideas. That stuff's all sort of inadmissible. So Judge Kaufman was not a fan of that idea of justice, and I'm really not either. He believed that to have a just outcome, you need to take kind of everything into account. Certainly obviously the language and what the framers of a law or a constitutional provision meant. But beyond that, what does it mean in society today? What are contemporary ideas of justice as it relates to really broad phrases like equal protection or, privacy or something like that? What's the latest, writing on it in the academy? Like he all of those things. What are the judge's own sort of moral or ethical impulses one way or the other? He didn't think you could really reach justice without taking everything into account. And I tend to think that's true.
I tend to think that's true also. I think of the word context, that you have to put everything within the context, including the year you're deciding the case, 2023, because we're a completely different society than when our Constitution was first drafted. So,
yes.
But, I'm not a judge, Martin.
No, even better, you have a great podcast. So.
Oh, well, thank you so much. I want to remind our listeners we've been talking just a delightful hour with Martin J. Siegel. And you can learn more about him. He's a Texas lawyer and he's author. You can learn more about him at his law firm website, which is siegelfirm.com, or at his author's website, martinjsiegel.com. And you can get his book, Judgment and Mercy, The Turbulent Times of the Judge Who Condemned the Rosenbergs, on Amazon.com in Kindle and in hardback. And you can also easily purchase it at his website, martinjsiegel.com. Martin, thank you so much. We really enjoyed our talk with you, and thanks for being on the show.
Absolutely. Yes. Thank you, guys. I really appreciate it.
Well, we get this edited. Robin and I do another little pitch at the end. You don't have to stick around for it. You can if you want to, but you don't have to. But
okay.
So far we've never had a guest stick around.
We hadn't had anybody stay. Yeah.
Yeah. Right. I guess I'll join the ranks.
That's right. But boy, this has just been fascinating. I've really enjoyed it.
Thank you so much. Yeah, I really appreciate it. I'm actually going to be in Georgia in 2 weeks. Weirdly, I'm going to be at the friend, the wife of a friend, also a friend, is an administrative law judge somewhere near Atlanta, I think, and they're having their conference, and so she arranged to have me come speak.
What kind of administrative law judge?
Man, that's a great question. I don't know. I mean, I know she handles.
There's really kind of two. I'm assuming it's a state administrative law.
State. Yeah, sorry, it's state.
So there's like the workers' comp judges, and then they've got a separate office of state administrative hearings, and they do like candidate eligibility. They do driver's license
standards.
Yeah, all this.
Yeah, I know she does. Like which one of those two types would do like school related stuff?
Probably OSA, the Office of whatever it's called, OSA. They do professional standards for teachers and that sort of thing.
Yeah, I could actually I'm going to look it up. I mean, she's right here in my email, so I'll just see what she's.
That's the same group. So
OSA. It is OSA. Yeah,
they had. You remember when? In fact, I got sort of asked to get in this case, but they wanted me to do it pro bono, and I didn't feel that strongly about it. But it was when Marjorie Taylor Greene, they were trying to get disqualified under the insurrection clause.
Yeah, I remember that.
It had to go to the OSHA thing.
Yeah.
OSA, yeah.
And of course, it was some group out of Massachusetts that wanted to do it, and they wanted me to sort of be local counsel for free. And I was like, I think she's awful, but I don't know that I want to be.
It seems like a long shot, and it was a long shot.
It was a long shot. Yeah. I can lose my paying cases without having to lose for free.
Yeah, exactly. Well, I was happy to get this invitation to come there. It's in Savannah, and they're flying me there. That's all going to be fun. But
it's beautiful.
Yeah, no, I know it's great. I just like the connection between this New York judge and this case, the Rosenberg case, and everything else, and this group of judges in Savannah was not apparent to me. So all I could ask her was like, do administrative law judges in Georgia now have the power to like sentence people to death? Like, is that? Please tell me that hasn't happened. So
no,
because that's probably next here. So we'll see.
Yeah.
I was I didn't know quite what to expect from that. I watched that Paxton impeachment, not because I care about Paxton, but because they had Dick DeGuerin and Rusty Hardin on there. And I, as a trial lawyer, those are two guys that, I hope when I'm 80, I can still, boogie my ass into the courtroom every now and then, But.
Yeah, well, it was an all-star lineup of litigators and the trial lawyers for sure. But I think that result was preordained. Yeah, sadly.
Well, thanks a lot, Martin. We appreciate it.
All right, thank you guys. Appreciate it.
All right, Lester, now is the time in our podcast where we always like to discuss a little issue in the news that's law related that caught our eye and seems kind of interesting. And the one that I have today is out of Maine, of all places. Seems like Maine's having problems with their lawyers. But Maine's top court affirms suspension of lawyer who asked staffer to take his CLE courses.
What possibly could go wrong?
So this attorney in Maine, there was a certain number of hours, CLE continuing legal education hours you could get online, but it was one of those where you had to prove you were watching by pressing a button every once in a while to say, I'm still here. And he didn't want to do that. He couldn't be bothered with that. So he asked his secretary to do that. And they got text messages between the secretary and the attorney that basically confirmed he had done that, and that he wanted her to hit the button to say, I'm present during the CLE. And the Maine Supreme Judicial Court didn't appreciate that very much. And so they suspended him. And then, as it turns out, he gets a little extra suspension because they found out that he had also been in, he had also had a personal relationship, I guess I should put it, with one of his clients in a divorce, and they didn't like that one either.
Well, I can certainly see the latter causing a problem for the lawyer.
Yeah, so he is suspended up in Maine, but lawyers don't have your secretary. Don't have your secretary take your CLE.
I'm kind of glad you told me about that second one, because as you were telling me about the CLE thing, which, obviously it's dishonest and it's stupid, but I was thinking, doesn't the bar know that their lawyers doing a lot worse things than that they could be out there looking for? But it sounds like this may have been tangentially related to
the other thing.
Extracurricular activities with his client there.
Right. I agree.
So
what's your news item?
My news item is from CBS News, and it's entitled "House Democrats Press for Cameras in Federal Courts as Trump Trials and Supreme Court Session Looms." And it's basically about a group of Democratic members of Congress who believe that they ought to allow television cameras in federal courts. And I'm going to diverge from my article just a little bit, because this is sort of based on the Trump trials, but I just want to talk generally, not, without regard of whether it's Donald Trump or Joe Biden or anybody else. But, the courthouse used to be a place where the whole community went and watched a trial and was able to talk about what was going on, to see what the people that were involved in that trial were doing. Yeah. And in this day and age, just like we don't climb up on the stump anymore, people get on social media or whatever else. To me, it's very key to have open courts, that people be allowed to see what goes on in there. Now, I know I probably won't win praise from any of my federal judge friends, because I think, it's a hassle and there are things that you've got to do, with that. But if you look at some of the hearings that have been held in the Trump trial, you've had journalists who have to basically have a runner go outside and get their phone to phone in, what's happening and things like that. So I do think, and for the U.S. Supreme Court in particular, for an institution that has that much effect on American life, what they do when they're about the people's business, I think ought to be something that the people ought to be able to see. So maybe this has been brought up at a time, because of this, but I think it's something that should have been brought up long ago, and not in the context of that one case, but in the context of every case.
I totally agree. It's long past due that we have TVs and show the public federal court cases. They obviously do it here in state court. Judge McBurney, as you've been in front of him, has YouTube
for the last
YouTube. Yeah, he has his own YouTube station, or what, I don't even know what you call it, YouTube. So every one of his criminal trials and the JQC stuff is on YouTube. So
that's what I've spent 4 days so far, and they you can go look at the comments too about what people think.
Yeah, it's like you have an ongoing focus group right as you're trying the case. Yeah. But we have often talked to judges who have been guests on the show. Does it throw things off? Does it throw a wrench in things to have cameras in the courtroom? And not a single one of them has said it bothered them or led to any lawyer acting out of turn or anything like that. They've had no problem with cameras in the courtroom. So that's a excuse that judges might use, but it's not realistic.
I always love the one, somebody's going to showboat on TV, like
correct.
Buzz TV. There weren't lawyers showboating in court. And you and I both know that there's one person that, if you're doing your job, you better show out for, and that's your client. And they're sitting
for sure. Yeah.
whether or not you're giving them a vigorous defense or putting up a vigorous case if you're the plaintiff,
I also like your point about it's the public's right to know and need to know, because I think if the public is involved and watches the trial and then there's an outcome, they accept the outcome more because they've seen the whole thing. Nothing's been in the dark. They understand the outcome and they accept it more. And I think that's very important for the rule of law.
And I think that's one reason, with the U.S. Supreme Court cases that have come down recently, you read, you just learn about it at the decision. It's not followed, going through. The public doesn't hear the arguments go back and forth, although now they do audio, stream them. It's really difficult to tell who's talking, what the situation is. But I think if you really want to instill public confidence in something, it needs to be out in the public domain where they can access it. Totally
agree with that. Let's hope it comes to fruition. We'll be looking for that. Well, what a great show. We want to thank our sponsor, the Georgia Civil Justice Foundation. You can learn more about the Georgia Civil Justice Foundation at seeyouincourtpodcast.org. We also thank our producer, Philip Hoover, and we thank our listeners. You can learn more about lestertate at aikentate.com and more about me, Robin Fraser Clark, at gatriallawyers.net. And you can find this episode and all of our episodes of See You in Court wherever you get your podcast. So until next time, Lester,
we'll see you in court.
Thank you for listening to See You in Court, brought to you by the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Please subscribe to this podcast and consider writing a review. You may find related documents to this week's episode on our website, seeyouincourt.podbean.com. Please send any questions, suggestions, or ideas to seeyouincourtpodcast@gmail.com.